Public Works got to it before you.
Good afternoon, ladies and gentlemen. Welcome to the February 25th, 2015 Legal and Finance Committee. Maggie, can we do a roll call and determination of quorum? Here. Thank you. Just to give everybody a heads up here, Chad Lewis is not feeling well today, so you get the pleasure of my trying to run this as a chair for this next full meeting. So what we have on the next is the adoption of the agenda. Do I hear a motion to adopt the agenda? I have Ron Weifenbach.
Thank you, Mr. Chair. I want to add an item, please.
Certainly.
And it's ADA agreement with the DOJ. Clarity
Do you mind if we put that down as number 18?
Number 18 will be fine with me. Thank you, sir.
Make a motion to approve the agenda as amended.
Motion by Wright, second by Laurenti to adopt the remainder of the agenda with the addition of item 18 from Ron Weifenbach. All those in favor say aye.
Aye.
Those opposed, motion carries. Now is the time for members of the public to discuss or express concerns to the council on any issue not on the agenda. Action will not be taken at this meeting on any issue not on the agenda except by placement on the agenda by unanimous vote of the council members present. And I have two general public comments from, first one is Jordan Mason. Mr. Mason, if you'll come to the speaker's podium and introduce yourself.
Thank you, Chairman. Due to the addition of the ADA agreement, it may be more appropriate for me to wait till item 18, given the subject matter I was going to speak on. It's
Sure.
Okay?
Yep, we can wait. I'll change it on here to item 18. And Mr. Freytag, if you'll come to the speaker podium and introduce yourself.
It's Bill Freytag, 3821 Brook Street. I wanted to address the commercial I seen on TV last night that said there was $70-some million in ADA and code enforcement that has to be done at the Civic Center, and I think you guys have all seen that. I'm glad to see our Brett's here from community planning, because you need to clear something with him, and that is this. On code enforcements, not ADA, the code enforcements in Rapid City, public buildings are exempted, and we are not required to bring anything in the existing Barnett Arena up to code. If you go over to the Barnett Arena and you add to the electrical demand and you put the existing electrical demand in danger, then you would be required by code to bring it all up to code. But otherwise, government buildings are exempt. And this has drove me nuts for years. Why in the world was I required to do this and that? And government was never required to do it, and it hasn't changed. And I know it hasn't changed because I've still checked it. When it comes to the ADA, the idea that we are required to do ADA is a myth. We are not required to do anything ADA to the Barnett Arena. Under Title II of the Department of Justice, Civil Rights Division, Disability Rights Section, Title II highlights, new construction and alterations. Public entities must ensure that newly constructed buildings and facilities are free of architectural and communication barriers that restrict access or use by individuals with disabilities. When a public entity undertakes alterations to an existing building, that's what you're doing, it must also ensure that the altered portion when a public entity undertakes the alterations, you have to bring those up to 2010 ADA codes. But the existing building, you do not. And what Title II is saying is that don't think for a minute, because you don't have to fix the Barnett, that means that you're going to get a status applied to the alteration that says you don't have to bring it up to 2010. You do the alteration, but you do not have to bring it up. You do not have to alter a single thing to bring it into ADA compliance on the Barnett. Now that's according to the ADA Title II, and you can go look it up yourself. Now there was a lawsuit between Orlando, Florida, and the city, and the Americans with Disabilities sued the city of Orlando on a similar project just like this. The disabled wanted the city to make the old part, bring it all up to code. They brought the new part up to ADA code, but they didn't the old part. They sued them. It was thrown out of court. It was dismissed. And it's in their documents in there several times. I'm just going to read you their conclusion from the court. In conclusion, so on page 10, you guys have all had the documents. I doubt anybody read them, but you all had them. On page 10, number 6, conclusion. After careful consideration, the court has determined that both the arena and the Bob Carr, when viewed in their entirety, are accessible and usable by disabled individuals. Title II, the regulations implementing it, and the admittedly sparse case law interpreting it do not require that facilities built prior to 1992 comply with the stringent technical standards imposed on facilities built after 1992. Consequently, the court cannot use those standards to determine whether the facilities are accessible. You have absolutely, it's a myth that ADA has to be, the 77 Barnett Arena has to become ADA compliant. It does not. The only thing that is at risk here is some kind of an agreement that somebody negotiated with DOJ that probably took a status away from the people of Rapid City and their building and the control we had of fixing our ADA the way we were, the way we have a history of, going in and spending millions of dollars and fixing it as recently as 2010. You took that away from us.
Thank you, Mr.
And you
Freitag.
let it go to the Department of Justice.
Thank you, Mr. Freitag.
All right, thank you.
I don't have any other speaker request forms at this time, and I want to make sure I'm not missing anybody. And that concludes the public portion of the comments section here. Now we'll move on to the consent items 1 through 16. I don't have any speaker request forms on items 1 through 16. Is there anyone that wants to remove items 1 through 16?
Item number 9.
Item number 9. Anyone else? Chair will entertain a motion to adopt the consent items 1 through 16 with the exception of item number 9. Moved by Laurenti, second by Darla Drew, and those in favor say aye. Aye. Those opposed? Motion carries. Item number 9 is the approved request for property tax abatement as follows. For Ed Aldridge, doing business as First Dakota Enterprises, Chadwick Jones, Elaine Hollis, Brad Bookbinder, and Brad Bookbinder for a second time. And the chair will entertain a motion, and Mr. Wright, you have the floor. Motion to approve. Is there a second? Second by Laurenti. And Mr. Wright, you have the floor.
I just know Chad Jones is here, and I know, Chad, if you want to question the action here or what's happening or what our results are, their finance officer could probably help you. But Chad, if you'd approach the microphone over here and just identify yourself, please.
Yes.
Yeah, Chad Jones here. This abatement we're requesting, we had purchased a property in Rapid City in April of 2013. We moved in November of 2013. When we signed the paperwork to buy the property, there was paperwork in there that said you must fill this out and turn it in by November 2013 through March 2014, which then would allow us to have this, what do you call it?
The abatement.
Yeah, it's Owner occupied,
Okay,
I guess
okay.
you call it. I mean, that don't make sense to me, but if it's a house, it's gonna be occupied. We did that. When my 2015 taxes come out, I said, you know, I believe taxes are always gonna go up, that's a given. But 23% is a little stiff. So I go ahead and go down to the Director of Equalization and we go through the records, and it kind of turns out that probably they made an error when they did this. So the lady I talked to said, I'll turn it over to her boss, wherever he is, and it'll go from there. So I guess this is where I'm at. My problem is I operate to a budget, and it's a damn strict one since I'm on fixed income. So I've got to know, is this going to go through this abatement or not? That's the only question I got. I think I deserve it because the system made a mistake, evidently. They didn't come out and say we screwed up. They just said something's wrong here. All right. So that's where I'm at.
Thank you, Mr. Jones. And Jerry, you still have the floor. And I'll turn it over
I'll
to
yield
Finance.
it to Pauline or Ron for now. Thank you.
Let me recognize the Finance Officer, Pauline Sumption.
Thank you, Mr. Chair. The recommendation is to approve all of these abatements.
And a short answer is he gets his money back. No, it's abated. Okay, all right. Very good. Mr. Weifenbach.
Thank you, Mr. Chair, and I appreciate it, Mr. Jones, and I understand when people are on a fixed income, this is important. And I agree that you should get this abated, but I've sat on this council and watched it get turned down from other people. But I think if it goes through Monday, as Pauline had mentioned, that we're gonna approve it here, it looks like, and then Monday the council will have to approve it. But I have seen it where it hasn't gone through for whatever argument, same type of thing. So, but that, you know, that being said, I can go along with it. I agree with it 100%. Thank you.
Thank you. Alderman Wright.
Just for the record, I think, I bought a house last year, and when we did the closing papers, if I remember right, we signed that property owned tax owner thing, and when it came around I had to go down and redo it. So could we check with the assessment or equalization officially and find out when they do closing statements if that document carries through or not? Or should I do that? Well, we do that when we did closing, and I think that's what you're talking about, right, Chad? Excuse me?
Folks, can I have you use the microphones, please?
If I might, Mr. Chair,
Yes.
they are required to do the paperwork, but I do know that some of our past abatements, there has been a glitch in the county system because they switched software systems. And so some of those owner-occupied statuses had inadvertently got
missed.
kicked out.
Okay.
And so they're going back and trying to correct all those as well.
Thank you, thank you, thank you.
Ron, did you have anything else to add?
Thank you, Rich. I was going to add the same, but like I said, I've also seen they have taken the stance in the past that if they make a mistake, it's still your mistake. So just so people know and go on the record saying that he did probably sign that as his closing, and it did probably go to the county, but it doesn't matter. If they make a mistake, it's still your mistake. That's the stance that was taken the last time I argued this on this council, which wasn't that long ago. So, and the council chose not to abate in that manner because the mistake was made. And this might be a little bit different because I think there's maybe a glitch in the computer or something, but hopefully we can abate this for him and truthfully charge him what he's supposed to be charged and not more. So, thank you.
Thank you. And Mr. Jones, I would recommend going down to the county auditor's office. Equalization, excuse me, and shortly after Monday night, because it looks like it's going to get approved. So my recommendation would go down there shortly, not right the next day or anything, but the paper trail has to be concluded, so I would recommend going down there after that. Thank you. The motion is still on the floor to approve. Those in favor say aye. Aye. Those opposed? Thank you for the help, Alderwoman Drew. Yeah. Moving on. That concludes now we'll move on to the non-consent items, items number 17 and 18. Again, I do not have any public comments on either items 17, excuse me, sorry. I do have a comment on number 18, and let's go to Jordan Mason. No, we're still under public comments.
Thank you, Councilman Nordstrom. Yeah, I just wanted to kind of clear the air because I'm a little bit concerned about some of the things that are being propagated, frankly, by what seems to be coming from the city and also some of the discussion concerning the Civic Center expansion. But I just wanted to touch base on actually what the settlement agreement said, because I keep hearing that we must come into compliance. The reality is that in the settlement agreement, which is the Department of Justice Agreement 204 TAC 69 TAC 50, it clearly states that it's a voluntary compliance agreement and stipulates that this is obviously under section C6A. It's due to the idea, and I'll quote here, in the event that Rapid City decides to build a new civic center. It goes on to describe that under attachment A are the actual complaints. And I guess I wanted to clear the air that there's been a lot of issues being stated that we must come into compliance with all of the items that were listed by the Department of Justice, which just is factually not true according to the own documentation that is on your website. I also wanted to touch on quickly, I've also heard it said by other public officials here that your engineers have stated that you have to come into compliance. The reality is, under March 25th, 2013, your life safety and ADA assessment report from Forefront Design actually says the opposite of that. On page 2, it says, and I quote, "Existing construction that was completed in compliance with the prior ADA standards is not required to be compliant with the 2010 ADA standards for accessible design and has safe harbor. All new construction, remodeling, and additions are required to meet the 2010 ADA standards." Then again, on page 4, it states, "After evaluating the Don Barnett Arena for Americans with Disability Act compliance, the assessment found that the existing facility is not in compliance due to the fact that ADA was not in existence and therefore not a requirement, period," end quote. I wanted to kind of clear the air because I'm kind of tired of hearing on the news and from public officials frankly, stuff that is just factually incorrect. In addition, I would just kind of like to point out the timeline of events for you. Let me flip here so I quote it correctly. Don't want to misspeak. Nope, one more page. Under Title II, which also falls under 28 of Codified Federal Regulations, Part 35, subsection 173, dealing with voluntary compliance, the Attorney General can issue noncompliance, and specifically, as is also stated in the agreement, the Attorney General is authorized to investigate an alleged violation. The problem is, to go over the timeline, again going over facts here, as it was reported on October 24th, 2012, Kelo, which obviously came from a Rapid City press release, that there was a complaint filed in August, just weeks after a City Economic Development Committee voted to explore it. Then on February 13th, 2015 of this year, we hear that there was confusion in whether or not a complaint had been filed. And then as of the last City Council meeting, our mayor publicly stated that he had called the Department of Justice Civil Rights Division. So I guess I would like some clarification on how, first off, the alleged violation was notified to the Department of Justice, and I think the public has a right to know, because thus far, according to the documentation, this seems like a very well-orchestrated ruse to me, because the statement to say that we have to do something by the facts is not true. Thank you.
Thank you, Mr. Mason. Jordan, if you would do me a favor, those titles that you've cited there, would you give them to Maggie for me, please? I just want to make sure I've got the correct titles.
Sure, be happy to write those down and copy them for you.
Please, thank you.
Yes, sir.
I don't have any other speaker request forms, so we'll move on to item, and I'm just making sure that I'm not skipping over anybody. Item number 17 is approve award of total base bid for Rapid City Sports Complex Phase 2 to be opened on February 10th to the lowest responsible bidder of J&J Asphalt Company in the amount of $2,020,808.25. Stand by, folks. All right. Let me go to Alderman Wright. Let me go to Alderman Wright first. You have a question.
Paulina's going to point out that she's asking actually for two separate motions on this. If she could clarify, I think there's a written. Are we going to do that, Steve? Okay, thank you.
Pauline, would you, or Ms. Sumption, would you care to elaborate?
Thank you, Mr. Chair. The first motion that I would like is actually to approve the additional funding additional funding in the amount of $600,000 from the Vision Fund undesignated cash to fund this project.
And so Alderman Laurenti made the motion to approve the addition, and is there a second? Second. Second by Alderman Wright. We'll go to Ron Weifenbach, please.
Thank you. And I just want to clarify, is this a vision project? It is. So this undesignated funds came from what's been left in the vision fund, is that correct?
Correct. We show currently 1.9 million of undesignated cash in the Vision Fund. I usually like to keep the $1 million balance, so we have the 600,000 too.
And we don't have any pending bonding obligations or anything because all the projects were pay-as-you-go in the Vision
Correct.
Fund? Awesome, thanks.
Yep. Very good deal. Does everybody understand the motion? And very good. Yes, we are. Everybody understands the motion, ready to proceed? Those in favor say aye. Aye. Those opposed? Motion carries. Thank you. Item 18 is from Alderman, I'm sorry.
Second.
Oh, I'm sorry. And that has to do with, thank you for correcting me, Pauline, I appreciate it. So the second motion is to actually do the award then?
Yes, to make the recommendation to approve the award.
Okay. Thank you for the correction. All right. Motion by Alderman Laurenti to.
Second, that's the motion.
Thank you. All right. Very good. Any other discussion? Those in favor say aye. Aye. Those opposed, motion carries. Thank you for the catch. Okay, thank you. All right. All right. Moving on to item 18 is an item from Alderman Weifenbach having to do with the DOJ report. Mr. Weifenbach, you have the floor.
Thank you, Mr. Chair, and I want to make sure that the council that is here understands my position on this. And what it is an ADA agreement with the DOJ. There's, as a councilperson, we are tasked with making decisions, and sometimes we make decisions based on information, and typically we have a chance to really dig into the information, especially when we're making big decisions. And in this particular item, I need some clarification because I've been asked on several occasions specifics that I had to delve into deeper, so I want to make sure that we get these items clarified. So most of my questions will be, Mr. Chair, will be directed towards our council. So, and if I may, the first question I have is
Proceed.
Yeah, who designed the agreement? Was it designed by our office or was it designed by the DOJ? Who
Mr.
drew it
Lundy.
up, I guess?
The Department of Justice. I think you'll recall when we approved it, I pointed to the Department of Justice website, the enforcement page for Title II of the ADA, and that there were numerous settlement agreements linked, and if you look at them, they're all fairly similar.
Okay, thank you. And then as I read and as I understood, and I want to make sure I completely understand and that we clarify this, that in the information I was given, there was an attachment for the department, the city of Orlando versus, I think it was Association of Disabled People or whatever, that they were suing the city of Orlando for not unlike what we are facing. They were doing improvements or had done improvements to their civic center, and that they were being sued for access to the arena, which was built prior to the 1990 ADA, and that action was dismissed. Is that correct, or am I reading that wrong?
You know, it's been a while since I looked at the Orlando case, but yes, I believe we did discuss that. I don't know if I used it by name and when we discussed it. You know, again, and I kind of covered this at the last council meeting, I think, pretty extensively, but what the discussion was is, do we have to bring it into strict compliance? No, you don't have to bring it into strict compliance, but unlike what Mr. Freitag was alluding to, all programs and all services of the city have to be readily accessible to people with disabilities. the Civic Center and including events we have in the Barnett Arena have to be readily accessible. Now, you don't have to bring a facility into compliance. You could move that activity or that service or that program to a building that was accessible, so it's readily accessible. So the question becomes, is the Barnett Arena readily accessible to people with disabilities? And what we discussed was that is a really subjective analysis, and it's very fact specific. The concern that we had is that when you have a report that identifies hundreds of violations, those are barriers to accessibility, and there are other court cases which say those can be used as evidence to show that the facility is not readily accessible. The example I used for the council when we discussed this before the agreement was approved is the ice arena was built in compliance with the ADA at the time. The safe harbor provision that they were referring to, that applies to the ice arena. The ice arena does not need to be in compliance with the 2010 requirements. Even if it did, I think we could make an argument that that is readily accessible to people with disabilities because it was built under a previous ADA standard and accessibility was considered when it was constructed. The concern I would have is if the Department of Justice decided to litigate this with us, going into court and arguing that the Barnett Arena is readily accessible to people with disabilities based on the violations we were aware of. What the council had a choice with when you approve this is to approve the settlement agreement and agree to bring it into compliance with the things that are identified in the settlement agreement, or to say, no, we're not going to enter into a settlement agreement with you. We think we're fine. And then that would have likely resulted in litigation with the Department of Justice over whether or not the facility was readily accessible. And we would have taken a similar path to as the city of Orlando did, litigating whether or not that the facility was readily accessible. At the time, I believe the council's opinion was it was better to, we needed to address the ADA issues and that it was better to just enter into the settlement agreement, spend the money on bringing the facility into compliance than it was to litigate with the Department of Justice to not bring the facility into compliance with the ADA.
I have a question because we were talking about the word safe harbor was brought up. The existing arena is not safe harbor. I completely understand it. I've read the law, and I wished, and I apologize to my constituents, that when I signed on this as a unanimous decision, if I could take one vote back, that's the one I would take back. And the reason is my understanding is that this building is an existing building and falls under a different law. The building's been built in '77. We have had no complaints for disability. I've talked to the Civic Center people 100,000 times about making sure that we're accommodating. I've made the comments to my council colleagues, if there is one person in our community that's not getting the quality that they want to have at the Civic Center, that we address it, and there's never been an issue with that. And we're reaching out, the Civic Center people reach out, but the problem I have with this is that as a council person, I rely on information. I think the information that I got wasn't fully vetted. And I think that, you know, going back on it after gathering it and seeing that the city of Orlando clearly won this almost identical similar case in the fact that there is options. This is not a do or die, and I think we understood that, but yet there's people out there that's saying that this is a do or die situation, and it's not. We've got money set aside. We can attack any of these issues as we feel, and if we feel that it's not a problem, we don't have to attack any of them. Is that correct? Is this an existing building under the ADA or not? Is it considered an existing building that's exempt from these improvements or not? That's a simple question.
That is where I think there's the misunderstanding. It is an existing building that does not need to be brought into strict compliance, but it still needs to be readily accessible. Is it readily accessible is the question.
And I agree. It's been there since 1977, and I think that it's readily accessible. I mean, and that argument could be made. The city of Orlando made that argument. I just want to make sure, Joel, that the information is correct that we're talking about out there. And I think there's a delusion that some people have illusions or delusions that if this is the citizens of Rapid City referred this vote, if they don't want it, it's not going to go away. I mean, the Civic Center is not going to close down. They're not going to strap yellow tape around and say, you can't go in there. The fact of the matter is, it's an existing building under ADA. There's court case with the information that you gave me, Joel. The City of Orlando versus the Association of Disabled People. This is an existing building built in 1977. It's been a long time. It's obviously, we've doing everything we can. And what I don't want to have happen is people think or have a delusion that we're not letting handicapped people in our facility. If you look at those handicap items, mainly most of them are the parking lot, which we should be addressing. We should have been addressing. They haven't been addressed. We got money in the vision funds. We could address these at any given time. And the fact of the matter is, we're not closing it. It's not have to be closed. I'm just bothered by the simple fact that now that we've entered into a voluntary agreement, are we tied to this agreement, Joel? Are we tied to it? Are our hands tied if the citizens refer this and they don't want it? And we've told the DOJ, well, we're going to build a new building, which we had no idea if we were going to build it or not. We thought we might. We had a pretty good thought it would get referred to, yet we signed a voluntary agreement saying, we're looking at building a new building, so let's just agree to all these things. So my question to you, simple, are we tied to this agreement if this thing gets voted down?
Mr. Landine.
Well, I mean, you could breach the agreement, and you'd be really in the same position as you were if you hadn't entered into the agreement, because at that point, the Department of Justice would need to make a decision whether or not, I think, even though you expressed that you believe it's readily accessible, I think the Department of Justice clearly doesn't think it's readily accessible. So they would have to make a decision. Do we proceed with litigation against the City of Rapid City to bring this facility into compliance? The purpose of the settlement agreement was to avoid litigation.
I don't think there was any, was there an indication of litigation?
Ron, hang on.
Yes.
Hang on. Let him finish the answer and then address the question to the chair, please.
Mr. Chair?
Yes. If I may have
let him
Mr. Landine finish the answer.
Yeah, the purpose of the settlement agreement was to avoid litigation. Now, whether or not, if we decide to back out of the agreement and say, you know what, now that either the vote has failed or whatever, we don't want to proceed with the agreement, then the ball would be in their court to decide whether they wanted to proceed with litigation or not.
Mr. Weifenbach.
Is there litigation pending? You acting like there's litigation percent?
No, there is no litigation pending.
That's my point. In Orlando versus the City of Orlando versus the ADA Association, they even had 2 complaints. And
Right.
They dismissed the case in this almost identical circumstance. And my problem now is why. And the other question I have is, has the DOJ even signed this agreement?
I have not received a signed copy of the agreement yet from the DOJ. It is my understanding it's in their PR department because they want to use it as a public relations to commemorate the anniversary of the Americans with Disabilities Act.
Mr. Weifenbach.
Then, thank you, Mr. Chair. Mr. Chair, I have another question. My question is, understanding and reading the agreement, rereading it, is that there's 30 months from the time they sign it, or 36 months from the time of the agreement. Is that correct?
Mr. Landine.
I'm not familiar with I would have to look at it for the 36, but yes, I would agree with the first part of the statement. That's 30 months from when they sign it.
Well, the reason I brought this to the legal and finance was because I'm tired of getting beat up. I'm tired of getting beat up by people telling me, you don't know the facts, you're misinformed, and because I question something, people say either I'm a naysayer, or I'm a hater, or whatever. I have questions, and on this particular thing, I wish that I would have asked more questions at the time, because I would have probably reversed my decision and said, you know what, I want to do everything we can to make it ADA accessible. I think I've made myself aware of that. There's things we could have done. We could have been attacking this for the last 5 years, no problem. There's plenty of money in the Vision Fund because it's a pay-as-you-go. There's an opportunity that these accessible items could be done right away. Then we enter into a voluntary agreement that's not signed. We have no commitment to sign it, but yet there's people telling us out there and telling the constituents who are going to vote that they have 30 months to complete this, which is a fabrication. It's 30 months from the time that this thing is signed. The DOJ hasn't even signed it. And then the other thing is I just don't like people to get beat up when they make questions. And the best opportunity for our city and our citizens to fully understand all the ramifications involved. If somebody's for it, fine, I agree with them. If somebody's against it, fine, I agree with them. Let's just hear the real information. Let's lay it out on a table and understand that we signed a voluntary agreement. And now I don't know if our hands are tied because we have a voluntary agreement to stick this kind of money. The other thing is the ADA, the numbers are wrong. There's $9 million in contingencies on there. What does that mean? $20 million to fix the repairs and $9 million worth of contingencies. I don't get it. And then I come to find out I relied on information that I made a bad decision, and to that I apologize. I made a bad decision, but after I went back and read it, I want to get the record straight. So when people ask me how I feel about it, or is this a mandate, they're going to shut down our arena because we don't comply. That's not the truth. The truth is that this is an existing building under ADA. It's been there since 1977. We haven't shut anybody out of that building. We don't plan to. We don't intend to. This city loves the ADA friends of the city. They're inviting to them. We signed a voluntary agreement. It's 30 months after the time they sign it. They haven't signed it. All signs point to the fact that the DOJ will not sue us. They have not sued us. There's no intention of suing us. Now we just got to understand, since we voluntarily agreed, and we understand, Mr. Chair, one more question. This is a voluntary agreement, right? It's not a settlement of any kind. We hired our own architect to take a look. My understanding is the DOJ spent 2 hours in the building. That was it.
Yeah, it was several hours. We certainly have a more comprehensive idea of what's wrong.
Mr. Chair, and we agree, Mr. Landine, that this building is existing under the ADA statutes.
It was an existing building under the ADA statutes.
Okay, so we agree with that. So we basically agree on everything. It's just
I wouldn't say that.
well, we definitely don't agree on whether we'd vote yes or no. I'm sure of that. I mean, you've made that pretty evident.
I think where the issue is whether or not the building is readily accessible.
Right, and I mean, it's been there since 1977, so.
That's not.
Gentlemen, if I can remind you to address your points to the chair, please.
Thank you.
Thank you.
I think that,
Mr. Lundin, did you finish your answer?
Yeah, I mean, the concern would be whether it's readily accessible, and until it was litigated, you wouldn't know the answer to that. There's arguments, the reason I included the City of Orlando case is that it would be an argument for. I don't know that it's exactly the same, but it certainly would be something that if we were in litigation with the Department of Justice, we would have relied on. But there's other cases that also cause concern as far as there was a case involving a fairgrounds where they allowed, in the grandstand, they had a handicapped area, and I would also say it's a similar situation to what we have where it was very hard to access. It was hard for people. There was no space for people that were attending with people with disabilities. But the fairgrounds said, look, the fact that we have people with disabilities who are able to attend and we have a space for them in the grandstand, that shows that it's readily accessible. And the court said, no, that in and of itself doesn't say you're readily accessible. You have all these it has to be meaningful accessibility, and we think this is a question for a jury. It's a question of fact that needs to go to a jury. So, when you have all these violations potentially of the ADA, I don't think it's as easy as just saying, well, the Orlando case shows that we're readily accessible. I don't think it does. It would be something we would certainly use, and it would be something in our favor. But then on the other side, there's all these barriers to accessibility that we've already been identified and we know about. And so it would likely have to go to a jury or to a fact finder to determine whether or not the facility was readily accessible. Anytime you go to a fact finder or a jury like that, you don't know what the result is going to be. So maybe they decide, yes, you know what, the Rushmore Plaza Civic Center makes accommodations. They allow, it's an existing building, it's readily accessible. That could have been an outcome. Could also be the outcome that they find the facility was not readily accessible. The question then also becomes, how much money do you spend on attorney fees and things litigating that in federal court, not knowing what the outcome was? And that was the discussion that I recall having before you approved the settlement agreement is, do you want to litigate this or not? You were not required to enter into that settlement agreement. The idea was, if you told the Department of Justice that you will voluntarily bring the facility into compliance with the ADA, so clearly it would be readily accessible, that they would not sue us. If you choose not to proceed with that agreement, then they have the right to sue us.
Mr. Chair.
Whether they would or not, I can't answer.
Thank you. Ron, any closing comments?
Mr. Chair, and I appreciate that, and I'll, you know, since you've mentioned that case, I'd like to see that case and show that if it's an existing building or whatever it was, if it's comparable, I'd like to share that since we mentioned it. And I agree that, you know, anybody can sue anybody for anything. And I remember sitting up here on the council and having the city attorney advise me that we can do whatever we want until somebody brings effect to it. But that's not my job, Joel. My job is to represent the citizens of Rapid City and make sure that they're getting a fair shake and make sure they understand everything, whether I agree with it or not. I don't make all my decisions based on my heart, whether I agree with something or not. I make the decision based upon what's best for the citizens of Rapid City. And nobody has ever suggested, had no illusions of anybody thinking that they couldn't address these things. That was never been said. So the opportunity for a lawsuit, fairly nil, just maybe zero, because the city of Rapid City would address them if they felt it was to that point or if it was necessary, and they have money available to address those items on a basis that would be pay as they go if they so chose, or a different approach of remodeling the building, leaving it open. Why they remodel the building, that is an option. It may cost more to leave it open and remodel it, but that's an option. So my thing is I want to clear the air so people quit asking me those questions so they understand them clearly. They can make their votes, whether they're for or against, whatever the case may be, in a manner that is clear, that they understand the ramifications of either way and understand the fact that nobody's here to close the arena down. It's been open since 1977. We just had a huge stock show event that was very successful. The weather was great. They did a great job promoting the stock show, and we had a lot of visitors. And that we appreciate, and we appreciate the fact that we're airing out the real issues on this ADA so we can air them out and make sure people understand it's not going to just be closed down. And I'll yield the floor. I've talked too long. Thank you.
Thank you, Alderman Weifenbach. And if you're, during your discoveries, would you do me a favor, if I can ask a request of you, is that whatever discoveries that you make, you share that with the Civic Center Board, specifically Jeff Bailey,
It's all information I've gathered from them. So
Yes. Any
it's
new
all
addition?
information I've gone on gotmine.com or I've gotten from our legal defense. It's all information they've got. So anybody wants it, they got access to it. All you have to do is read it. I would challenge everybody to read it. Read the ACOM report, read the ADA information. Just read it. Please, just read it. Just read it. That's all I ask.
Thank you. Alderman Wright.
I'd like to make a motion that item 18 be forwarded to the council without action for further discussion, and I have one question to add to that. If that's...
You have the floor, Mr. Wright.
A statement was made that the city is not liable to meet codes, life safety, and building codes and that kind of stuff. Is that true? I don't think. My experience was we are. I'm not. You're not the expert on it. I want our people to answer that, please.
I made
Thank
the
you.
statement.
Brad,
I was willing to-
you're not. I'm not asking you, Jordan. I'm asking our officials. I'm just getting clarification. The motion is to send it to council without action.
If you'll introduce yourself, Mr. Solon.
I'm Brad from City Development Services. What was the question?
Is the city of Rapid City required to meet the building codes, life safety, such as fire, electrical, power, heating, and so structural? Are we required to meet those codes?
I would say that we are, but that's a legal question. I think I'd like to have confirmation.
But
from
can we get
Joel.
that clarified and discussed Monday night along with the ADA issues? That's my point. Thank you.
Okay, all right. Thank you, Mr. Wright. Anything else?
No.
Okay, thank you. The motion on the floor is to send this to council with further investigation, and seconded by Alderman Laurenti. Those in favor of the motion?
Aye.
Those opposed? Motion carries. The chair will entertain a motion to adjourn.
So moved.
Motion to approve, motion to adjourn. Those in favor, say aye. Those opposed?
No, I just.
Motion carries. Thank you.